No, just the screen. Yeah. Yes, sir. Yes, yeah. All right, court is going to call 2022 CR 105, I'm sorry, 2022 CR 10756, State of Texas versus Scott Marcellino. Can I have parties announced for the record for the state?
For the state, Ruben Herrera and Brittany Mitchell.
Defense?
Jessica Gonzalez for Mr. Marciano.
And are you Mr. Marcellino?
Yes, I am.
All right, are both parties ready for trial, state?
State's ready, Your Honor.
Defense?
Defense is ready, Your Honor.
All right, defense, have you received all of the discovery in this case and did you review it with your client?
Yes, Your Honor. There's just a couple of additions that I wanted to put on the record since I made announcements yesterday.
Yes.
The information of the police report, the missing police report, the protective order application and affidavit, and the actual miraculously received PS police records were all turned over to me last night or yesterday at the end of business day.
All right, thank you. Oh, okay. Cool. All right, Deputy, you can bring in the jurors.
I know this person.
Ooh, looks like it's done.
Yeah.
What? First row at the end.
Stand up.
So numbers are on the screen.
Every time the time is going in and out, we always do them.
For 8. 8-second row on top.
I didn't want to point it out, but
15. Have a seat.
hopefully I will remember to give you a copy instruction before the proceeding. But that's the first one. Yes, Your Honor.
30.
Yes, ma'am.
So
Everyone. It's international paper. All right, everyone, please be seated. All right, everyone, good morning. Okay, that is very weak for a Wednesday and half of the week is over. So everybody should be happy because we're closer to Friday. Good morning, everyone. Awesome. All right, I'm Judge Stephanie Boyd. You're in the 187th District Court. It's on the 4th floor. Judge Boyd, 187th District Court, 4th floor. So which floor are we on? What court? Who's the judge? All right, I know you're probably saying, why would she have us repeat that? Why is she asking that of us? The reason why I do that is because we cannot have jury selection unless all of you are here. And sometimes we'll take a break, and when we take breaks, because there are so many courtrooms in the courthouse, sometimes people get lost. We've had it where we've been looking for a juror and they've been trying to get selected on another jury panel, and we have to grab them. And then we've had jurors who say, I just looked up and everybody was gone. So if you ever get lost when we take a break, all you have to do is say, hey, I'm in Judge Boyd's court. I'm the only Judge Boyd in the entire courthouse. Or either if you say 187 District Court, this is the only 187 District Court in the courthouse. So if you remember those two things, you will not get lost. So to my left is the court reporter. Could you raise your hand, Diana, please? All right, so I'm going to give you an instruction about this court reporter. And I'm hoping that you will be the first jury that will follow this instruction. All other jurors have failed. So I'm having faith, because it's Wednesday and it's close to Fiesta, that you all will follow this instruction. So everybody has white cards. If you're sitting on them, don't sit on them. Pull them out, because we're going to need them. All right. Can everybody hold up their white cards? Now, if you're in this box, keep your card up. If you're on this front row, keep your card up. Everybody else, lower your card. Everybody else, lower your card, except for people on this front row and here. All right, everyone else, lower your card. Number 54, lower your card. All right, number 47, lower your card. Everyone else, keep your card up. So if your card is not raised, anytime you speak, if you can, I'm going to need you to stand. So if your card is not raised right now, whenever you're talking, you need to stand. The reason why is because the court reporter will not be able to hear, because the sound is not good. All right, so you all can raise your hand. I mean, you can lower your cards. So if the court reporter cannot hear you, then she doesn't take it down on the record. And the worst thing for court reporters is if their record goes up for somebody else to read it, and there's a bunch that says inaudible, unable to report. Because believe it or not, when that shows up, people think the court reporter is not a good court reporter, and it reflects on them. So let's make her job easier. We're going to talk where she can hear us. If I'm talking too low, let me know. If you can't hear what I'm saying, let me know. The other thing that will make her job easier is everybody, when you're talking, only one person at a time. And I know we're used to, when we're in conversations, that what we do is people tend to talk over each other because you know where the question is going, or you know how a sentence is going to end. But don't do that with her, because that will make her job more difficult. And if you can imagine, with court reporters, you have all these different people that you have to take down every single thing that they're saying, and everybody's speaking at a different pace. Everybody's speaking at a different volume. Some people have accents. I have a Southern accent because I'm from Louisiana. Some people don't. So just make sure you speak at the level that I'm speaking at, so that she can hear. And all those people who did not have their cards raised at the end, if you're going to address a question, then you'll need to stand if you can. All right, I want to have the parties introduce themselves. Representing the state, we have.
My name is Ruben Herrera, and I'm here with my partner, Brittany Mitchell.
And for the defense.
Good morning, everybody. My name is Jessica Gonzalez, and I'm my partner is going to be Tracy Franklin.
All right. And then Mr. MARCELLENO.
MARCELLENO Scott.
Thank you. All right. So all of the people that you just saw stand up, does anyone recognize any of those parties? All right, what's your number, sir?
21.
All right, and number 21, who do you know?
You know the good lawyer over here in the black suit.
Okay. All right, now the charge in this case is continuous family violence. Now, I'm going to circle back to more information about that, but I want you to know when I talk to you, when either of the attorneys talk to you, they are going to be speaking in hypotheticals. Neither side is allowed to speak to you about what they think the facts in this case will be. Does everyone understand? The only time you will get a chance to know what each side believes the facts are will be if you are on the jury. Does everyone understand? Now, I want to talk to you about an indictment and what it means. How many people here have ever had a traffic ticket? I'm getting you to practice raising your cards. Raise your cards. All right, there are a couple of people who've never had a traffic ticket. Number 20, I salute you. So I've had one traffic ticket in my life, right? And back in the day when I got my traffic ticket, even though I'm only 19, back in the day when nobody's supposed to laugh at that. You know, you're supposed to say, oh, wow, she's so young to be a judge. But when I got my traffic ticket, those were days, excuse me, miss. That's okay. Now, which court are you looking for?
No.
All right, if you can find out which court she's looking for. All right, there may be people who come in the courtroom from this door. It's because they don't read the sign that says we're in jury trial. The people who are coming through this door are usually staff who have paperwork or something for me to sign. It has absolutely nothing to do with this case. And sometimes people who come through that door are lost because, as I said, people don't know all the courtrooms. And then they're not paying attention to the sign. And the person who's sitting here, they're here to observe. So some people may just want to observe jury trials. You have some people who want to become an attorneys and they want to see if this is something they really want to do. So back to traffic tickets. So when I got a traffic ticket, the officer, they had the little paper book and they gave you the paper ticket. I think now they do it electronically or something. So if you get a traffic ticket for, let's say it's running a red light or not following the rules of the yield sign, which people in San Antonio don't know what the yield sign is for. I think that happens in all states. When you accept that ticket, you're not saying that you ran a stop sign or you ran a red light or you didn't follow the yield sign. That ticket is just telling you, this is what the officer is saying you did. And then you can go to court and go to trial. Indictments are the same way. Indictments are just telling someone, this is what we're accusing you of. It is no evidence of guilt. It can't be taken as a sign of guilt. Does everyone understand that? Is there anyone here who will not be able to follow that? Is there anyone here who thinks just because someone is indicted, then they're guilty? All right. Now, there are certain rights that, constitutional rights that people have when they're charged with an offense. One of those is the right to remain silent. Has everyone heard of that before? All right. Where are my Matlocks, my Mannix, my Barnaby Jones people? Thank you. The other people don't want to own it. They're pretending like they're so young, but there's reruns on TV. So everyone has a right to remain silent, which means that you don't have to testify. Now, why wouldn't somebody do that? People always want to wonder, well, why I would do it, I would testify. There are many reasons why somebody may decide not to testify. Maybe they stutter. Maybe they're afraid of speaking in public. Maybe their attorney said, hey, there's no need for you to testify. There are many reasons. And The thing about it is, this is not Bewitched. You're not Mrs. Kravitz. You're not supposed to investigate and try to figure out, ooh, I wonder what they would have said. You cannot hold it against someone if they decide not to testify. You cannot consider it whatsoever on whether a person is guilty or not guilty. Does everyone understand? Is there anyone here who would hold it against Mr. Scott if he decided not to testify? All right. The next thing I want to talk to you is about presumption of innocence. Everybody who's charged with any type of offense is presumed to be innocent. What does that mean? That means that as Mr. Scott sits here, until it's proven that he committed an offense, and until it's proven beyond a reasonable doubt, he's presumed to be innocent. So if you all had to vote right now on whether Mr. Scott was guilty or not guilty, your vote should be not guilty because he's presumed to be innocent and you have not received any evidence. Does everyone understand? All right. Now, the burden of proof lies with the state. The state must prove each and every element beyond a reasonable doubt. Now, I know what you're asking yourself. Stephanie, what is the definition of proof beyond a reasonable doubt? When I was in law school so many years ago and graduated, I had my first jury trial as a defense attorney. And I was so proud of myself. My mom was proud of me because I knew the definition of proof beyond a reasonable doubt. After that jury trial, guess what? The definition that I knew forwards and backwards is no more. It no longer exists. There is no definition for proof beyond a reasonable doubt. So as I continued being defense attorney and when I became a prosecutor, what I would tell jurors to help them understand proof beyond a reasonable doubt was by telling them what it was not. So there's a courthouse next door to us. It has the green rooftop. They handle civil cases. You have, when it's a car accident or usually involving money, those cases, the burden of proof is preponderance of the evidence. More likely than not that something occurred. Proof beyond a reasonable doubt is higher than that burden. The next burden that's on the civil side, which was one of the highest burdens on the civil side, is something called clear and convincing evidence. Clear and convincing evidence is the evidence that is needed for someone to terminate your parental rights, to say, you're not a great parent. We think it's best that you no longer legally be a parent to your children. That's a high burden. But the burden that is highest in Texas, and that's higher than that, is proof beyond a reasonable doubt. So that is the state's burden. The state has the burden to prove its case beyond a reasonable doubt, and that burden never shifts to the defense. The defense doesn't have to prove anything. The defense could read crosswords puzzles, play Sudoku. I don't think they're going to do that. They could go to sleep. I don't think they're going to do that. But they don't have to prove anything. So what does that mean? They don't have to call witnesses. They don't have to put any evidence on. Does everyone understand? All right. Now, there are two phases to a trial. First phase of a trial, some people call it guilt innocence, but really what it is, the first phase of a trial, a jury or a judge determines whether someone is guilty or not guilty. It's really not guilt innocence. It's really, is someone guilty or are they not guilty? That's phase one. Phase two is what's called the punishment phase. Of course, if someone's found not guilty, there is no phase two because there's no punishment because they've been found not guilty. In Texas, it's required that if someone is going to trial on the criminal side, they must make an election or a selection of, if they were found guilty, who would decide punishment. It's the law. The fact that they are making a decision who they would go to for punishment is in no way evidence of guilt. It's just what must be done, and it's a part of the legal process. Is there anyone who doesn't understand that? All right. In this case, Mr. Scott has chosen that if he were to be found guilty, the jury would assess punishment. Is there anyone here for religious reasons who feels as though they could not sit in judgment? Okay. Now, I want to talk to you about range of punishment. For this offense, the range of punishment could be probation, and it could be anywhere from 2 to 10 years in prison. That's the range of punishment. It's a wide range of punishment. Now, when you're thinking about punishment, some people will say, well, maybe I could consider giving probation, or maybe I could consider giving 2 years, 3 years, all the way up to 10 years. Because you don't know any facts in this case, the question for you is not whether you will give probation in a case like this, or whether or not you would give 10 years in a case like this. The question is if you could consider it. So that's the range of punishment in a case like this. Up anywhere from probation up to prison. Does everybody understand the range of punishment? Now, with regards to these type of cases, a person may be eligible for probation. Does everybody understand? It's not saying, oh yeah, I'll give probation every time. People want you to keep an open mind. So the question I have for you is whether or not in a continuous family violence case, you can consider probation. Is there anyone here who cannot consider probation? Okay. Is there anyone here who could not consider the full range of punishment? Now, the next thing I want to talk to you is something called the one witness rule. I'm going to give you a fact scenario. Do not add to my fact scenario, people. People have always wanted to add to it. This is your fact scenario pertaining to the one witness rule. Somebody comes to testify. They raise their hand. I swear them in. They're sworn to tell the truth. They say, I do. I will tell the truth. You listen to them testify. And you believe them. You believe they're telling the truth. And that one witness proves the state's case, proves every element beyond a reasonable doubt. Does everybody understand my hypothetical? There is no question about, well, were they wearing their glasses? Were they wearing contacts? There's no issue for them with identity, because if you're questioning in your mind, were they wearing contacts? Were they wearing glasses? That means that maybe you don't that means that maybe you don't believe their testimony beyond a reasonable doubt. So in this hypothetical, this is a witness where you believe their testimony, they're credible, and their testimony ticks off every box that the state has to prove. Everybody understand? So hold that hypothetical in your mind. And now I'm going to give you ask you another question. If you have someone, and let's say that person is in a parking lot. 2 people are in the parking lot. One person and another person. Just 2 nondescript people. Person 1 gets robbed by person 2. Should person 1 be able to come into court and testify to what happened to them? Is there anyone who says, you know what? It's 2 people. Person 1 said person 2 robbed them. Person 1, I'm sorry. It's only 2 people there. You and the person who you're saying who robbed you, there's nothing we can do. Is there anyone here who thinks that person 1, sorry, it's only you and that other person, so we're not going to do anything? Is there anyone here who feels that that would be right to person 1? Okay, so back to my hypothetical. If one person were to come in and testify, you believe them, and they tick off all of the boxes that the state has to prove beyond a reasonable doubt, will you be able to find someone guilty with that one person that you believe? Is there anyone who would not be able to do that? Okay. Next question I want to talk to you about is languages. I absolutely love languages. I never thought I would be in Texas, so hence I learned French, even though my classmate was saying, Stephanie, we should take this Spanish. I think we should. And I was like, no, I'm doing French. I'm going to be living in France anyway. Well, lo and behold, here I am, barely 19, and I'm in Texas. So I love languages. All of my friends who were in law school, because I ended up going to St. Mary's, a lot of them spoke a lot of languages. And I probably know the words hurry up in every language because that's all they were teaching me. So is there anyone here who English is not your first language? If English is not your first language, if you could raise your card for me. Number 7, 33, 40, 57, and 61. All right, number 7, what is your first language? Say hurry up in Spanish.
Hurry up.
No, say it in Spanish. I'm like, they told me wrong. I didn't know hurry up in Spanish was hurry up. All right. Have you been able to understand everything that's been said? All right, thank you. 33. Don't fail me. I have faith. Don't fail me. Oh, look, everybody's covered. Thank you. All right, juror number 33, what's your first language? All right. Have you been able to understand everything that?
Yes, I do.
All right, thank you very much. Juror number 33. Number 33, could you stand up? No, 33. Yes. How do you say hurry up in Spanish? I'm going to see if number 7 told us correctly.
Korea? Korea.
Okay. All right. Thank you. We're going to have to talk to number 7 later. Number 40,
Spanish as well.
you broke the rule. Spanish. All right. Thank you. 57. I'm sorry. You know what? You're the second person we've had from the Philippines. Have you been able to understand everything? All right, I'm gonna need you to speak up.
Yeah.
All right, thank you. 61.
Judge, my first language is Spanish, and yes, I have been able.
All right, thank you very much. All right, the next question I want to talk to you all about is travel arrangements and time constraints. So is there anyone traveling anywhere and you cannot transfer the tickets in my name? They're non-refundable. All right, number 1. Oh, well, here's the thing. I don't think we're going to be here in May. So if you're here for May but you still want to tell us about the poor souls who are staying here about your fabulous vacations, you can. All right, number 1. Oh, you're out. Okay, 15, 20, 22, 23, 26, 32, 58, 62, 72. All right, number 15, what is your time constraint? And where are you going? Oh, wow. What are you doing in Iceland? Oh, wow. Okay. Is it going to still be cold there? Or?
It's
Right.
like 40 and 30 right now and raining. So probably.
Yeah, a couple of my friends went to Iceland. They really enjoyed it. Number 20.
Mine is more medical. I'm having eye procedure next week.
Okay. What day next week?
It's the 17th, the 19th, and the 21st. And then the following week, I'm having a back injection.
All right. You chose Fiesta to do this. Okay. Hopefully the doctors are not going to Fiesta, then coming back and saying, let's do this. Okay. All right. Number 22.
I'm traveling for work between starting next week on until June.
What date?
Each week. I'm going all across Texas.
No, I mean, what date are you starting your travel?
The 18th.
And where are you traveling to?
Dallas, Houston, the Rio Grande Valley, Permian Basin, being Houston and Dallas, Austin, Corpus.
Are you just naming every city in Texas?
There's a prospect, that's where we're going.
All right, so what do you do?
I'm a people change leader, so I help companies or organization with
Changing people?
people change leaders. Yeah, I just help people change.
I should have done that. Okay. I've never heard of a people changer. Okay. What are you change? Just out of curiosity, when you say changing people, what are you changing them to?
So when an organization is making changes to the company,
Uh-huh.
my job is to make sure that we're finding the right balance between the business rule, but also for the people itself. That way they have a good experience regardless. So like when COVID was happening, how we find a way to be able to send workers on a hybrid schedule without impacting the business, but also having a good impact.
Oh, well, thank you. All right, number 23. Yes.
Yes, ma'am. I'll be traveling the 19th to the 23rd, Florida.
Oh, what are you doing in Florida? Vacation? What part of Florida? Okay, all right, thank you. Number 26.
Yes, ma'am. I'm going to Monterrey, Mexico from tomorrow until Sunday.
All right, what are you doing in Monterey?
Vacations. That's it.
All right. All right, thank you. Number 32.
This Friday, I'm actually gonna be going to Iowa to get my grandmother's funeral.
Oh, I'm sorry to hear that.
Tuesday, I'm actually going on my
Oh, I'm not gonna ask if she wants you there.
honeymoon.
Yeah, okay. Because it's brand new, so people always want to be with the partners when it's brand new. So Iowa on Friday. All right. Number 58.
Yes, sir. I'm going to El Paso on the 20th to visit my grandmother.
Okay. And are you going to be cooking for her? Or are you expecting her to cook for you?
No, it's me and my mom. We're going to visit her after her, she had like surgery on one of her knees. We're just
Okay.
going to visit her after the surgery. And taking care of us for a little bit.
Okay, awesome. That's the 20th. The 20th.
Yes, sir.
All right, thank you. Number 62,
Rock, Arkansas.
the 28th. What are you doing in Little Rock, Arkansas?
Okay, buddy, family.
Okay, all right, thank you. Number 72.
Canada from the April 27th to May 2nd.
And what are you doing in Canada? I'm sorry, what?
Niagara Falls.
Oh, wow. You know, that's on my bucket list. And how do you say, what language do you speak?
I speak English and Idoma.
All right. How do you say hurry up? All right, thank you. The court reporter is thanking you as well because she can't put that in. All right, so since all of you have had a chance to sort of get to hear everyone else speak, number 25, now she's being emboldened. All right.
I just wanted to make sure about the time constraint frame. It's from today through May.
Oh, no. I don't expect us to be here in May. I mean, it could happen,
I
but
just want to make sure it's either through this week and the rest of April.
yeah, I understand us in May. All right, thank you. 31.
I have a job interview at 1 o'clock Friday.
Oh, what are you interviewing for?
I'm a project manager with CPS.
Is that CPS Energy?
Yeah.
Okay, well, I don't know if you should have said that. I think people want to talk to you about their bills or something. So, all right, 31 is CPS. All right, number 8.
I babysit my granddaughter full-time.
Okay. How old is your granddaughter?
A year and 3 months.
She's not driving yet?
No, not yet.
Texas, you're disappointing me,
Just saying
Texas.
No to everything.
Yeah. Okay. All right, number 10.
I'm
Oh, you can remain seated. You're in the box.
traveling to Chicago to see my daughter on the 29th of April.
Is it going to be cold there?
Hope not.
Hey, but you know what? Just think of the 100-degree weather we're probably going to have here. All right, so any other 34?
I'm sorry, are we still on this travel constraints or other?
I mean, what constraint do you have?
My son who lives out of state and I never get to see him is coming in tomorrow. And I will get to see him like once a year. So that's it.
Oh, where is he coming from that you only see him once a year?
He lives in Los Angeles and he travels all the time for his job. So it's rare that our schedules.
You need to get him together with number 20, with the people changer, number 22, and have him talk to his job. All right, so number 41.
April 26th, I'll be going to Austin.
Vacation in Austin. I mean, I like Austin. I mean, Austin is where I learned that peacocks can fly. I mean, truly, peacocks can fly. Yeah, they can fly. So I learned that in Austin because they have a nice peacock reservation or preservation or something. All right, so the 26th. Okay, all right, thank you. I can't believe you're leaving San Antonio during the time of fiesta to go to Austin. Okay, awesome. All right, anyone else? All right, so now you've got a chance to see each other. So do any of you know any of the jurors other than you all being brought from downstairs and standing in line outside? All right, 26, 27, anyone else? 25.
One of the state council attorneys looks familiar to me.
Okay. It's not from cutting in line or anything, right? Okay. All right, 26 and 27. I hope you are the two people who know each other, because if not, oh, well, there are two people who are not claiming you guys. All right, number 26, who do you know? Okay. Oh, that's how you know. Oh,
I've never met him before, but I just read him.
all right, thanks. Number 27, who do you know? All right, awesome. Well, the rest of you, how can you not know him? All right, number 30.
Same thing.
All right, so anybody else how many people, I'm sorry, what's your number?
21.
My number is 21, ma'am.
All right, so number 21, if you could stand up and turn around, please. How many people know number 21? All right, so nobody has to raise their hand for knowing 21. All right, thank
Clearly
you.
not doing a good job.
All right, so anyone else know anyone else other than those people? Well, that is odd. Usually we have teachers and their students or co-workers or wives and ex-wives, but this is the first time we've actually had that before, but they got along. All right, so I'm going to tell you two stories, and both are true, because I always tell people, I know jury duty is a hassle, right? It's a hassle because you have to come downtown. And I don't know why in every American city, it seems like every downtown, they want to have several one-ways. And then you have to pay for parking. Then you have to wait. Then you have to come up here and wait in the hallway. Then you have to find the restrooms. I know it's a hassle, but when you think about it, your government does not ask a lot of you. The only thing they ask for you, pay taxes and jury duty. They don't even ask you to vote, although I think everybody should vote. They don't even ask that of you. This is the one thing they ask of you. So when you think about it, if people are saying, oh, we have the best legal system, we can't have the best legal system without having jurors, and we can't have jury trials without jurors. So my family originally grew up in a small town in Louisiana called Grand Cane, Louisiana. I think in its heyday, it was probably like maybe a population of 2,500 people. Now it's probably like a population of, I don't know, 850 people or something. So my uncle was super intelligent, and he would get passed from grade to grade to grade because he was super intelligent. And of course, you know, his sisters who came up after him, they would always say, hey, your brother's super smart. You all got to show me something. Well, when he graduated, and he graduated underage because he got passed in school, the Vietnam War breaks out. And so they started drafting all of the boys from Grand Cane, Louisiana. And my uncle tells my grandmother, there's really not much opportunity for me. I'm not going to wait to be, I want to just go off and go to Vietnam. So my grandmother, he's my grandmother's firstborn, she actually had to sign for him to go and fight in Vietnam. And if you can imagine, those were the days, there's not a cell phone. There's not where you can email and say, how's my son doing? So it's just the snail mail. You write a letter, see what's happening, and people are being killed. So when people say jury duty is a sacrifice, for me, that's a sacrifice. You're sending your firstborn, you're signing for him to go off. You don't know if he's going to come back or not come back. So when your country is asking for you to do jury duty, that's not a big sacrifice. We don't even have the draft anymore. Until something changes with the legislature, there's no draft. You don't even have to fight in the war if you don't want to fight in the war. So this, I know it's inconvenient. And I say inconvenient, I don't consider it a hassle. It's just like some inconvenience. But this is all your country is asking of you. The other story, and my uncle made it back from Vietnam, but he's since passed because people always like, what happened? So he came back. But the other story I want to tell you about is one of my friends from law school. They wanted to do civil law. I've always wanted to do criminal law. So on the criminal side, you're usually in court every single day with your client. You're usually in court trying cases. So she gets called up for jury duty. And she's like, we'll be able to have lunch because we hadn't had lunch in forever. I'm like, yeah, this is great. We'll have lunch. So on a break from jury selection, we end up going for lunch. And I say, how's jury selection going? She's like, it's going fabulous. Now, mind you, in present time, I'm thinking, how could it be fabulous? You were not in the 187 with Judge Boyd, right? So she said, it's going fabulous. I said, why is it going fabulous? She's like, I'm not going to be selected. I'm like, what do you mean? She's like, it's like law school. I'm keeping my head down. I'm in the back. I start laughing and she's like, what's so funny? I said, we are going to be able to have lunch all week. This is awesome. She's like, what do you mean? I said, you're so getting selected. And I see her afterwards. She's like, how did you know I was going to get selected? I said, because the quiet ones always do. So I tell you that story to tell you that both the state and the defense, they want to get to know you. They only have this small window to get to know you because they want to make sure that people who are sitting on the jury are people who are fair and impartial, people who will just listen to the evidence and base your decision on whether someone is guilty or not guilty on the evidence that you hear. I realize that all of us may have experiences in our background, but the main question is whether or not, if you're selected for this jury, can you base whatever decision you come to on the evidence that you hear in this case? Does everyone understand? All right, if anybody ever needs a break, just do the break sign. So does anybody need a break before I turn it over to the state to begin their questioning? All right, so each party will have 30 minutes.
Your Honor, I need
Yes.
to approach an issue.
Okay, sure. All right, ladies and gentlemen, this is what I'm going to do because there may be a slight discrepancy on the list that we have. So I'm going to give you all a short break. If you need to go to the restrooms, wherever you see the stairs, the restrooms are on either side of those stairs. So if it's crowded at one restroom, if you go down a floor below, restrooms on either side. And then when we come back, what's gonna happen is the state is gonna have 30 minutes to speak to you, and the defense will have 30 minutes to speak to you, okay? All right, so whenever we break, everyone has to leave the jury room, but leave the courtroom. But since this is a short break, if you want to leave your personal items behind, you can leave your personal items. I'll still be here. The deputies will still be here, okay? All right, everyone, please rise. Leave your cards behind them, please.
She's on one of this. Send that one, there's, I think we can do it. Oh, yeah. You can do it now. Can you do it now? Yeah, they're walking in. Do it like this.
All right, state,
Yeah, no, it's a different
you
grade.
may proceed.
Good morning, everybody. My name is Ruben Herrera. I'm a prosecutor for the state of Texas. I'm here again with my partner, Brittany Mitchell. As the judge said, you're all here for jury duty. Congratulations. So what I want to talk with you, I want to get to know you guys like the judge said, but I'm going to go through some points of the law that may be concerning this case. Again, I can't go into any of the facts of the case. The only way you'll be able to hear that is if you're actually selected to be a juror. But throughout this presentation, I'm going to ask some questions. If you all look down at your feet, there's no trap doors there, so there's no wrong answers. You can give any answer. The goal of today is to find a panel of 12 fair and impartial jurors, and I'll go through what that means. But the only way to do that is to get your honest opinions, honest answers to any questions that we ask for myself and for the defense. So participation is key. Again, we have a rule here that says you talk, you walk. So the more you talk, the more chance there is that you might not be selected for the jury, which you don't have to raise your hands, might be some of y'all's goals today. But the more you talk, the more we get to know you, the more we know your opinions. The less you talk, the more likely you are to be on this jury here. So choice is yours. But here we are. The case that we are presenting is State of Texas versus Scott Marcellino, also known as Marcellino Scott. Again, this meme might be some, if not most of you. But like the judge said, it's an important role in our judicial system to have people participating, fair and impartial jurors, in order to move these cases along, so that somebody doesn't have a case pending for 4 or 5 years. We can move these dockets along, and it just makes for a well-oiled machine in the judicial system. So what a fair and impartial juror is. Who here knows who this guy is? All right. Number 35, who's that up there?
That's Will Nelson.
All right. And if you can tell from the picture, what is Mr. Willie Nelson known for? What does he smoke? Okay. Do you think what he?
Smoked marijuana.
All right. Now, as y'all know, smoking marijuana is currently illegal in the state of Texas. If we were presenting a marijuana case in court today, does anybody here think that Mr. Willie Nelson, who is a proponent for smoking marijuana, does anybody think that he would be the ideal juror, a fair and impartial juror in the case? Yeah, right. So that's what our primary goal here is today, finding fair and impartial jurors who can set aside any of their biases, any of their preferences, and hear the facts of the case and be able to decide, be able to render a verdict based on solely the facts of the case. So a fair and impartial juror means that you'll be able to follow the law the judge gives you. as well as basing your decision only on the facts presented in this case. Now, in order to render your verdict, we need to prove the elements of the charge, which is continuous violence against family, beyond a reasonable doubt. Like the judge said, there's no real definition of what beyond a reasonable doubt is. It doesn't mean that we have to prove it beyond all doubt. So it doesn't mean that we have to prove it 100% that this is what happened on the date in question. You may have doubts as to what possibly happened. However, just because something is possible doesn't mean that it's reasonable. So again, we have to prove beyond a reasonable doubt. And I'll show you an example of what I mean in just a second. But even if you do have a reasonable doubt about a certain fact that we bring up in the case, that reasonable doubt must go to an element of the offense that we present to you. So you, for example, you may find, oh, I was wearing a red shirt or a blue, but it comes out it was a blue shirt. Sometimes people's stories gets mixed up. May you have a reasonable doubt about whether the shirt was red or blue? Yes. But does that go to an element of the offense that we're presenting? No. So beyond a reasonable doubt, when you're deliberating on a verdict, we ask that you ask yourself 3 questions. So number 1, do I have a doubt about this case? Number 2, is that a reasonable doubt? And number 3, does that reasonable doubt go towards one of the elements that we as a state are required to prove to y'all? So here's a picture here. I have a new puppy. He's 5 years old, and he likes to tear up all the furniture. Last night I went home and he tore up his bed. But from this picture, can anybody kind of give me an idea of what happened here? Dog was bored, and what did he do? Okay. There you go. Now, nobody here actually saw that dog tear up the chair, right? Right? But is it reasonable to think that anything else other than that's what occurred from what you see here in this picture? Because, for example, it's possible that some random stranger walked in through your front door and said, I don't like that chair, cut it up, and then left. It's possible, but is that reasonable given what you see in this photo? So that's what we're talking about when we're talking about a reasonable doubt here. So this is the charge, continuous violence against family, that the defendant is charged with. And the elements of the offense are that there was an assault causing bodily injury to a family or dating partner, and later on I'll go through what that means. And that an assault occurred 2 or more times during a 12-month period. So essentially what we're asking you to do is look at 2 separate incidences of assault, and we'll go more in depth into what that is also, and finding that those occurred to a family member or a dating partner within a 12-month period, okay? Those are the elements that the state's required to prove, and we're required to prove those to beyond a reasonable doubt. But what's assault? In Texas, there's 2 different categories of assault. So there's assault causing bodily injury, which the elements of those are that the defendant intentionally, knowingly, or recklessly caused bodily injury, again, to that family member or dating partner. There's also assault as a threat, in which they intentionally or knowingly threaten imminent bodily injury. Now, the mens rea, or the intentionally, knowingly, and recklessly, I'll break those down a little bit for you as well. So we have to prove one of those 3. Doesn't have to be unanimous, which if you all decide it was intentionally, recklessly, or knowingly. All that matters is that we prove one of those mental states to you beyond a reasonable doubt. So intentionally is the conscious objective or desire to engage in the conduct or cause a result. So if I walked up to somebody that I saw on the street that I didn't like and punched him in the face because I wanted to hurt him, that's intentional. I caused that action in order to cause that result of bodily injury, right? Knowingly means that they're aware that the conduct is reasonably certain to cause a result. The same example, if I walk up to somebody and I just punch them, not wanting to hurt them necessarily, but I punched that person. I knew that by punching that person in the face, I could cause bodily injury, right? And then finally, there's recklessly. This one's a little bit more difficult, but in order to be reckless, you have to be aware of the consequences, but consciously disregard a substantial and justifiable risk that the circumstances exist or the result will occur. And an example of this would be, if we all stood in a tight circle and I just threw a baseball up in the air, I knew that it might hit somebody, it might cause somebody harm, but I didn't care. I just wanted to throw that baseball up in a crowded room and see what happened. So again, as long as we prove one of these mental states to you beyond a reasonable doubt, then we've met our burden as to whether the defendant intentionally, knowingly, or recklessly caused bodily injury, okay? So we, again, doesn't have to be unanimous as to which of the three, as long as we prove to you that at least one of those three mental states was present. Now, how do we know someone has acted intentionally, knowingly, or recklessly? Well, we can infer that from the facts of the case, as well as the words and actions of the defendant and the victim. So, I mean, somebody doesn't have to come up to you and say, hey, I'm going to punch you and I'm going to hurt you, and then throw that punch. But you can infer that from other facts of the case and other actions. If there's an argument, if there's a fight that's already been proceeding, something like that, you look at the surrounding facts of the case and you can infer what that mental state was. Sometimes they do say it, sometimes they don't, but we ask you to look at all of the facts. You can't read somebody's mind, and that's the reason why we ask you to infer. Now, the other element of the offense is bodily injury. What's bodily injury? It's physical pain, illness, or any impairment of the physical condition. And what we want to stress to you is that under the law, pain is enough. Now, it doesn't have to be a broken bone, a torn limb, anything like that. So then that would be a felony. That'd be a separate charge. But here, because we're asking you to find 2 assaults, pain is enough. How can we tell somebody is in pain? Anybody have any examples? What's one way that you know that somebody's in pain? What's your number? 19. What did you say?
They say ow.
They say ow. They express that pain verbally. Number 24. Scream or yell, again, verbal. Somebody else had an answer. 58.
They're like holding their arm or something.
Okay, so something strikes them and they go.
You know, they can't.
If you want to stand up.
Oh, yeah, sorry. They're like limping or holding their arm or something.
Okay.
Yeah.
Anybody else? Number 31
Crying. They're crying.
and number 7.
There's an impairment of some sort, like they are limping.
Okay, yeah, so there's many different actions that somebody can, you can infer that somebody's in pain without them directly saying, hey, that hurt, or I'm in pain, right? There's multiple different ways. And sometimes they don't express it verbally, but sometimes they do something physical, like holding a body part that's just been struck by something, holding a body part that's, that's in pain, really. So again, you can infer that pain as long as you find that there was pain. So another example of what causes pain, a hair pull. Anybody had their hair pulled and right away, like, oh, that hurt, right? I mean, it happens pretty commonly. How else can you tell this little girl's in pain? Facial expression, okay. So again, there's multiple different ways that you can infer pain. Now, we're going to go into a little bit of the family violence section, because that is another element that we have to prove for the offense. Now, family and dating violence encompasses all sorts of different relationships. So it encompasses a dating relationship, and that in itself encompasses former dating partners and current dating partners. So they don't have to be dating at the time the offense occurred. As long as they had a prior relationship, that fits under the family violence umbrella. Yeah, sorry about that. It also incorporates spouses, and that's the same, former or current spouses, parents of a child and their children, regardless of whether they're married or not. It encompasses foster parents and their foster children, as well as siblings. What family violence includes is an act by a member of the family or the household as well against another member of that family or household. As long as that relationship is present, that's a family violence action. Number 27.
So for the sake of this conversation, is the umbrella term family violence or is domestic violence the umbrella term?
They're interchangeable. It's the same. Like I said, family violence also includes dating violence. Dating violence, what that includes is an act other than a defensive measure to protect oneself that's committed against a victim with whom the actor has had a dating relationship. So again, it's another violent act that's not in the defense of themselves or another.
Are you considering verbal as well, or is it just strictly the physical?
It's only physical. This doesn't, an assault is physical. It could also be a threat, but for this purposes, we're only including the physical action,
Not emotional.
not emotional, exactly. Now, I do have a question for all of y'all. Does anybody here agree, or I'll ask here. So the question is, family violence is a private matter and the state should not get involved. Now, I'm gonna go through these 4 different categories. I'm just gonna ask you to raise your number as to which one you agree with. So who strongly disagrees with that statement, that family violence is a private matter and the state should not get involved? If you strongly disagree with that. Number 2, 3, 4, 5, 6, 7, 8, 9. Are you holding your number up? 9, 12, 13, 14, 15, 16. And when I call your number out, you can put it down. 16, 17, 20, 21, 22, 24, 25, 27, 28, 29, 31, 34, 35, 37, 38, 39, 40, 41, 43, 44, 45, 46, 48, 48, 49, 50, 51, 52, 53, 54, 57, 58, 59, 65, 66, 67, 68, 70, and 72. Thank you. Now, who here disagrees with that statement? Number 1, number 10, 23, 26, 32, 42, 47, 56, 60, 61, 62, 64, 71, 73, 74, and 75. Who agrees with that? That family violence is a private matter and and the state should not get involved. Number 11, 18, 19, 36, 55. And who here strongly agrees? Anybody? Okay, all right, thank you. So why is it important to prosecute family violence cases? Anybody? Well, what about the relationships between the defendant and the victim? Is there any importance in order to prosecute based on the relationship? Anybody think so? Number 31? Do you want to stand up?
Family dynamic, power structures, times it's insular and people get trapped in it. So if there's not an external person that can see and act on it, forever.
Okay. Is there anybody that has the same thoughts as number 31? Let's make this easier. Who doesn't agree with 31? Anybody that doesn't agree with 31, their kind of idea about that? Okay. Who typically are victims of family violence? 27?
Women and children.
Okay. 25? 24? Same thing? Anybody have anything different than women and children? 41? The elderly? 43?
Anybody.
Anybody. There you go. Anybody can be a victim. Do victims of family violence always leave their abusers? What are some reasons why or why not they wouldn't leave? Number 24. Okay. Somebody who hasn't spoken. Number 19.
They have kids.
They have kids and it's just too hard to leave. Number 5.
They feel trapped and they're afraid they're gonna get beaten.
Anything different from anything we've already said? 14. I'm sorry, what was that? They love them. Number 18, I'm sorry, they're dependent.
Family members to take care of them.
Okay, so what I'm gathering is sometimes people might just be stuck in the relationship and they can't leave on their own, right? Okay, so that's why it may be important to prosecute these kind of cases, because sometimes the victim of family violence doesn't have a voice for themselves, or they don't have the means to do it themselves. And that's why we have these kind of cases in this courtroom. Now, the law of the case that we'll be presenting, again, it's an assault bodily injury to a family or dating partner, which by itself is a misdemeanor. So we're required to prove that those elements to the assault, which would on its own, again, would be a misdemeanor. The last element that it occurs 2 or more times during a 12-month period or less, that's what enhances it to a felony. So in essence, we'd be presenting 2 separate occurrences of an assault bodily injury to a family member or a household member within that 12-month period in order to satisfy the elements of the felony. Number 26.
Does it have to be the same victim?
No, it does not. Number 55.
Is this like a 3 strikes rule, or is it just?
It's not. It's one crime. It's 2 separate incidences that are incorporated into one crime. Okay. Now, I do want to talk about a little bit about types of witnesses in these kind of cases. Now, where does family violence typically occur? At home? Okay. Is it more likely to occur at home or in a public setting?
At home.
At home? Okay. And who's usually around when an act of family violence occurs?
Children.
I'm sorry.
Who's around? Children.
Okay, children may be present. Is there anybody else? Number 58.
It could usually be other family members, like aunts and uncles sometimes as well.
What's your number in the back? 54. Do you want to stand up for me? Just so the court reporter can hear you. That's, yeah, that most of the time it is just those 2 people around. So when that occurs, who would be a witness to the events that happen? Anybody? No, number 70.
Neighbors might be able to cross the street or the house next door.
Okay, but if it's happening inside the house, how likely is it that somebody would be number 21?
The victim and the perpetrator of the video.
Yeah. So they would be the only 2. If there was anybody else around, they'd be up on the stand as well, right? Sometimes it is just those 2 people that know exactly what happened. So how many actual witnesses are usually able to testify? When the 2. Now remember that the defendant has the right not to testify in the case. So how many are left? 1, right? The victim. Now, is that a problem for anyone if the state is only able to provide 1 witness to the events that occurred? Yeah, I'll start over here. Raise your number if it's a problem for you. Number 12, 19, 18, 26.
See it potentially, I don't know.
Okay. 46, did you have yours up? 45, 58, 61, 62, 63, 64, 55, 56, 49, 66, 68, 70, and 74. So if
I'm sorry, just one moment. All right, ladies and gentlemen, what he's talking to you about is the 1 witness rule. Does everyone remember the 1 witness rule that I went over? All right, so you understand that he's talking to you about a 1 witness rule.
Yes.
All right, State, you may continue.
Thank you, Your Honor. Now, if we don't have any witnesses to the offense, how is the state able to prove their case? Anybody have an answer? Number 74?
Can you stand up, please, sir?
Yes, if there have been repeat offenses, have the individual call 911, all signs of abuse.
Okay. Number 39?
Hospital records, if it was.
37?
Investigating officers that responded to the scene.
Okay. Now, does anybody think that we should be prosecuting these cases where we only have the word of the victim to testify?
No.
Number 8, you think no? Why do you think no? Okay. Okay, no, that's fair though. Does anybody agree with number 8? That we shouldn't prosecute the family violence cases when the state only has the word of the victim to go on? Number 18 and number 19? Number 73? Anybody over here? All right. So I'm going to throw out an example for you, a hypothetical. If you had to be robbed, would you rather be robbed in location A, in this alley, or in location B, in Austin, at a football game? Who would want to get robbed in the alley? Raise your number. Okay. Because there's no witnesses? Okay. Now, that's kind of the point. If we had all these witnesses to testify, we'd have the perfect case and we wouldn't be here trying any of these cases, most likely, right? However, the problem is that sometimes there isn't. Not everybody has a surveillance camera capturing all the footage as it occurs in their household. Not every family violence case happens at a family party where there's 10 different people there to see what happens. Most of the time, it is in a location kind of like this alley. They're in a house, and when it's just 2 partners, and all we have is the victim to be able to come in and tell their story. So that's the reality of these family violence cases and why we do proceed on them, because they're not always going to be the perfect case where they're being physically abused or mentally abused in a location with millions of people to watch. So another example, after you leave jury duty today, you're walking to your car and you're robbed. No one's around to see. You call the police, make a report, and the suspect who robbed you is dismissed or is arrested. Should we dismiss this case because nobody else saw you get robbed and we only have you to testify?
No.
Okay. Number 8, no? Okay. So that's why we proceed on these cases, because most of the time it is just the word of the victim that we have to go on. Like the judge already went over with you the 1 witness rule. The law allows us to prove our case with just the one witness, which usually is the victim, as long as we meet those elements of the crime beyond a reasonable doubt. And everybody's already answered whether or not they have a problem with that, so I will move on. Again, just another example of the 1 witness rule. Now, I'm going to ask a question. If only 1 person testifies, that's not enough to find someone guilty. Who here strongly disagrees with that statement? That if only 1 person testifies, that is not enough to find someone guilty. Number 4, 12, 20, 21, 27, 28, 29, 30, 31, 34, 35, 37, 39, 40, 41, 42, 44, 50, 51, 52, 53, 54, 56, 61, 65, 66, 67, and 69. And 15? Yes,
Does that include just their statements or is that evidence?
just 1 witness, 1
What
person
is it- what
testified.
the person saying or is it evidence?
It really encompasses just 1 witness, so it could be the victim, could be somebody else, but we're just talking about one person testifying. Yeah, because testimony is evidence. I should have explained that a little bit, but yes. So
Clarify.
if you want to stand up, and then what's your number?
To clarify, testimony is evidence, but physical evidence. Clarify, physical evidence plays a big part.
Yes, it does. But we're talking about just the testimony. Okay. So who disagrees with that? Number 1, 2, 7, 9, 6, 10, 11, 13, 16, 17, 20, are you? No, okay. 22, 23, 24, 25, 32, 33, 36, 38, 47, 48, 58, 59, 60, 62, 63, 64, 68, 71, and 75. And 15, were you holding yours up? And 15. Who agrees that if one person testifies, that's not enough to find them guilty? 3, 14, 5, 18, 19, 26, 43, 45, 55. What's your number? 70, 73, and 74. Does anybody strongly agree with that? 46? Okay. All right, thank you, everybody. Now, knowing that the law allows for finding of guilty if only one witness testifies, and you believe that witness beyond a reasonable doubt as to every element, and we've proven every element beyond a reasonable doubt through that one witness, would anybody not be able to render a verdict of guilty? Again, one person testifies, we've proven every element of the case beyond a reasonable doubt, and you believe them beyond a reasonable doubt, would you not be able to render a verdict of guilty? Anybody? And again, there's no wrong answers. Okay. Now, continuing on to the witnesses, how are some ways that we can determine if a witness is credible, if they're believable? 21.
Prior crimes committed, prior inconsistent statements.
Okay. So through their testimony, anything of inconsistency coming out. Okay. Anybody else have any ideas? Number 25. Their background. Okay. 54. Okay. So in other words, their demeanor, right? Okay. Number 53.
Possible hidden agendas or motives.
Okay. I think you guys might have seen this PowerPoint. As motive, right? Okay. What about what they say on the stand? You know, again, going back into prior inconsistent statements, anything like that. Consistency in their statements. 26. Do you have anything different?
Maybe if, like something they say gets challenged on cross.
Okay. So consistency still, right? Okay. You know, looking at the consistency in their statement from different
Time.
point- Yeah. Okay. Thank you, Unai. Just briefly, really quick, looking at their points of views, their perception, and their time frame, as well as the time that's elapsed between the offense date and here. So I will pass it on to the defense now, and they'll have some more questions for you. Thank you, everybody.
Defense,
Can I get a 5-minute one?
yes.
Thank you. Or push another button.
It shows your,
Got here early this morning to make sure I can get this to work. So, like I said this morning, my name is Jessica Gonzalez. I have the pleasure, along with my co-counsel, Tracy Franklin, in representing Mark Scott. That's actually how we introduced ourselves to us when he came in and hired our law firm, Dunham and Jones. Can everybody hear me? Everybody? Okay, good. The state of Texas and Judge Boyd went through a lot of information, and I'm really glad they did because my PowerPoint is really, really long, but now we get to fly through a lot of my slides. But I do want to go back and touch a couple of different points. So we already talked about the role of the judge and the role of the prosecutor, criminal defense attorney. I think everybody understands the purpose of what we're here for. So something I do want to emphasize, though, is the role of the jury. If you're actually selected to hear the case as the jurors, you, the jurors, should actually be given your own black robe. You guys are actually going to be the ones that are going to be judging the case. The judge is here to be a referee to make sure that we follow all of the rules, but you guys are the ones that actually judge everything. So you guys are going to be judging the evidence that's presented to you, the facts, the credibility of the witnesses, and how much weight you're going to give to all of the things that are presented. You're bound by the law that's given to you by the court, but you and you alone are the judges of everything. So everybody already talked about what makes a good juror. I think we understand what's going to be involved and what we wanted you guys to come here to do today during jury selection. So let me introduce myself again. Again, my name's Jessica Gonzalez. We all know that. I want to do my jury selection where we're having a conversation. It's a conversation between me and each and every one of you guys. Just so you guys know a little bit of my background, when I went to college, my intent was to become a teacher. Specifically, I wanted to be a professor. What that means for you is if you guys aren't talking, I'm going to call on you and ask you questions. So get used to it. Every single person. My goal is to get to speak to at least 50 of you. Okay. So maybe 60, you may be okay, but I don't know. I haven't decided yet. So we all know, or we should have learned during the state's case, or I'm sorry, the state's jury selection and the judge's instruction, my client has several constitutional rights. We know the big ones. What's the big one, Councilman?
The presumption of innocence.
The presumption of innocence. He now becomes my favorite juror on the panel. So they're actually, okay, anybody else? Juror number 1. Do you know what is one of the constitutional rights?
Right to remain silent.
Right to remain silent. Juror number 2.
That's what we're doing.
Sam. Okay, juror number 3. I can say that. Juror number 3.
I was gonna say the same thing.
Juror number 4.
The right, not to testify.
Right not to testify. Kind of goes along with those, but in different ways. Very smart. Juror number 5.
Same thing.
Same thing.
A fair trial?
Right to trial. Juror number, what's your number, ma'am?
7.
Juror number 7.
I can't think of anything else.
Okay, juror number 14, do you have something different? Does anybody have anything else different? Because I feel like there was one that it was kind of missed. Okay, juror number 50.
An attorney.
Right to an attorney. Juror number 55, something different?
You have the right to be judged by a panel of peers.
Okay, juror number 25. Okay, what? I feel like we've missed one. Juror number 21.
Right to face your accuser.
Thank you. Bingo. Again, you got it. It is your right to be able to cross-examine the witnesses. Okay, so I think we now hit all of them. These are all very important rights for my client, a person who stands accused of a crime. So let me go and let's see if juror number 21 can get this. Who is on trial today?
State. They have to prove their case.
Exactly. Now, who else here, when I ask that question, who is going to say my client, Mr. Scott? Anybody? Juror number 20? Juror number 14, juror number 15, and this is an informal poll, but most of you guys thought when you came in here and you looked at the setup in this room, you guys thought you're here to be able to judge and that my client is the one on trial today. But our councilman, juror number 21, actually hit the nail on the head, right? Okay, the state of Texas is actually the one on trial today. And that is because of our law and our law of presumption of innocence. All persons are presumed innocent and no person may be convicted of an offense unless each and every element of that offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. Like Judge Boyd said, I could sit here and I could fall asleep. I got a good night's rest last night, but I could do that. He does not have to show you anything. The presumption of innocence alone is sufficient for you to acquit the defendant. Now, I need to change up my slideshow because way back when I created it, the slide that we would talk about with the state and defense was usually a slide that shows this. Juror number, let's see, where did I leave off? So juror number, ma'am, what's your juror number? Juror number 15. What do you think's going on here?
Right.
Juror number 16, do you agree with that?
I don't have my long distance classes.
Okay. Juror number 17, would you agree with that statement?
Yeah, I'd say
Training. Okay, that's what we would think, right? Okay, juror number 18, what do you think's going on here? Being arrested. So juror number 19, did you do something wrong?
Maybe.
Yeah, baby, I like that answer. But juror number 20, when you're driving down the road and that's what you see, that's what your intuition, your gut is telling you. Your first question is, what did that person do wrong? Right? That's where your mind goes. That's natural. But like the councilman said, and like I'm saying to you right now.
Number 11 raised their card.
I'm sorry, juror number 11.
Yes, that's for the policeman just to be protected. in
I'm
case
sorry?
something happened. He's protected, the cop was protecting himself.
Okay, That would be a possibility,
Yes.
right?
Okay, so.
And so nothing would happen. Okay. So as we stated, who's on trial today? So the other thing you're gonna learn about me is I love law and order and I love pop culture. So here we go. Dun, dun, dun. Law and order trial by jury. That's who is on trial today. You're here to judge the state's case. What is it that they have proven to me? And we're going to circle back to this one witness rule because I think this is what a lot of people were starting to have questions on. Okay, so how do we judge? How does a jury judge the state's case? Everybody's has, do you guys know what this is?
My cousin Dave.
Thank you, number 60. My Cousin Vinny, one of the great legal movies. And if you're an attorney, you've seen this 1,000 times because that's how a defense attorney goes and does that cross-examination. They go and they ask the witnesses. They go up to each one of the pieces of evidence that are presented and they show the jury where the flaws are in that evidence. That is the role of the jury, is to be able to critically analyze that and look at that evidence and judge the state's case. So why is it important for that Mark, that's what he likes to be called, be given a chance to confront the witnesses against him? Let's see, we've gone 21, so 22. Why is that important?
To get his point of view across, or just to figure out what happened during the events?
Okay. So who here, juror number, so that was juror number 22. Juror number 23, are you on social media? Okay. Raise your hand if you're on social media. Informal poll. Raise your hand if you're not on social media. Okay. For those of you that do not have your social media presence, do you know what social media is? Okay. How easy is it for somebody to say something on social media? Yeah. Anybody can get up there and say anything. Okay. How is it you get to the bottom of it and find out what the truth is? So I left off ma'am in the blue shirt, juror number 24. How do you find out what's actually the truth? You ask questions. Juror number 25, would you agree with that? Okay, juror number 26.
Yeah, I look for primary sources.
Okay. So that's what the big thing is. And I think that's where a lot of people are getting hung up on this one witness rule. You got to remember, Judge Boyd, when she explained this to you guys, she specifically stated juror number, okay, so that was juror number 26, right? Juror number 27, what did she say when she gave you, before she gave you the hypothetical about it? Do you remember? Juror number 28, do you remember? Juror number 29? Don't add anything to my hypothetical. She asked that question specifically in saying, do not add to my hypothetical, because in her hypothetical, it was relying on the premise that you as the juror believed the witness, okay? However, when you're sitting here on the jury and you're listening to the evidence, your role is actually to judge that witness, judge what they're saying to you. To see, and like I said, I put in here, you are the exclusive judges of their credibility and the facts proved. So that's that assumption. When you're looking at the one witness, her question, and I think what the state was talking about, and then people started, going back and forth and maybe pulling back from that. You're there to judge them, and if you don't believe that witness, if listening to their testimony. And we'll get to other parts of it. But if listening to that testimony, you start to have that doubt, and that doubt is a reasonable doubt, you can find them not guilty. In fact, that's what the law requires you to do, is to find my client not guilty. So perception is not always reality, and reality is not always the same as what we perceive. Informal poll. Raise your hand. Oh, actually, let's go ahead. Juror number, where do we leave off? You in the red and black striped shirt. What's your number, sir?
31.
31. So 30 is next to you because I can't see. Number 30. What do you see here in this picture? It's black and white. Okay.
I'm sorry.
Can you stand up?
Black and white.
Black and white. Okay, juror number 31. What do you see?
I see a person with their head turned away.
Okay, juror number 32. Do you see an old woman or a young woman?
I would say, like,
Okay, juror number 34.
Oh, yes.
I'm
young
sorry.
woman.
You see a young woman. Juror number 33. Do you see an old woman or a young woman?
Young woman.
Okay, so raise your hand if you see a young woman. Raise your hand if you see an old woman. We're all looking at the same picture, right? But we can all see two different things, right? It depends on what your perception is, and that's the same thing for any witnesses. What if a witness is far away? They could possibly see something different than what actually happened, right? So juror number, I'm sorry, what's your number, ma'am? 6? Okay, so that's a true statement that I was saying. They can see something different, right? So juror number 6, how is it that we get to finding out that information? If we're in trial and a witness comes up here and says something, what would I be needing to do to get that information to you on the jury?
Well, I mean, I guess you would have to deliver facts or
I ask questions.
ask
Right?
questions.
I mean, I ask questions. Again, that's why that confrontation is so important. So it depends on their viewpoint. It depends on if they're distracted about something. It depends on how far away they are. It also depends on preconceived beliefs. If they already have something in their mind of what they think would happen, that affects how they remember it, correct? Okay. How can you tell if a person is telling the truth? Where did I leave off, ma'am? In the black glasses? What's your number? 34. How can you tell if a person's telling the truth?
Get to the bottom.
Okay, juror number 35.
I would say based on their confidence in the answer.
Okay, juror number 36. Stand up. You have to stand up, sir. Okay. Juror number 37. How can you tell if a person's telling the truth?
based on their answers, the demeanor of themselves and the answer questions and so forth.
Okay, juror number 38. Body language. So, okay, juror number 39. What about if their story, when they come up and testify, what if it matches or doesn't match the evidence? Would that be an indicator?
Good or
It depends, right? Okay, so let's look at the opposite way of it. And your number is 39, right? Okay, how can you tell if a person's lying? Juror number 40.
They change the story a lot, they're fidgety, you know, they look nervous.
Juror number 40, that was 40, right? 40, juror number 41. How can you tell if a person's lying?
Same body language. Stuttering.
Okay, nervous tics, testimony doesn't match. So juror number, you're number 42, right? 41, sorry, I'm really bad at numbers. 42, why would a witness lie? Can you stand up, please? Why would a witness lie? You don't know? Juror number 43, stand up, please.
Cover up something.
Cover up something. Juror number 44. Okay. Juror number 45, stand up.
Retaliation.
Retaliation. Why would somebody want to retaliate? Juror number 45, if you can stand up.
A bad history between the partners, and I just don't think.
Okay. Juror number 46, go ahead and stand up. Defamatory purposes. So yeah, okay, you're number 46, right? Juror number 47, go ahead and stand up. What about when somebody's feeding them a story or they're trying to protect a loved one? Would that be a reason why somebody would lie? Okay, a child on behalf of a parent, right? Or what about a sibling? Siblings, they lie about each other all the time, right? And then on the other side, sometimes they tell each other the truth because you got to stick with your siblings, right? So it just, there's a lot of different factors that will play into this. So that is why this is so important. Now let's go ahead and talk briefly about police officers. Now, they're there to protect and serve, right? But like the state said, a lot of times these cases happen in private. So officers are making the scene after something has already occurred. Sometimes they may see something, but sometimes it's after the fact. So, Juror, were you 47 or what's your numbers? 48. Okay. So sometimes officers will show up afterwards. If they're not seeing something, who are they getting their information from? The victim. Who said the witnesses? Number 8, right? They're getting it from somebody else. So saying that an officer is a liar, that may be kind of true in the technical sense, but it may just be simply because somebody else gave them that information. They had incorrect information when they started, right? Juror number 1, right? So when an officer gets to the scene, do we want them to do a complete investigation, or do we want them just to go off one story? A complete investigation. What happens, juror number 49, what happens, go ahead and stand up. What happens when an officer only does a limited investigation?
Could be any one of those shown on screen or
Yeah. They miss evidence. Juror number 50, are we up to 50?
Yes.
They jump to wrong conclusions, right?
Yes.
And then juror number 51, if you can stand up because you're in that corner. Now, when that happens, if you're sitting on the jury, do you think you're going to be able to get all of that information if they miss stuff? No. And you want everything when you're sitting on the jury. Would you agree with that, juror number 52? Yeah. Do you want to see everything, or do you want the limited investigation? You want to see everything. Can you say that again? She wants to see everything. Would everybody agree with that? You want to see everything, and then you guys make the decision of what you think happened that night. So now we'll go through quickly. We've already talked about it. There's different levels of lying. It can be something like where the officer just didn't have everything. It could be somebody exaggerating about what happened. It happened kind of that way, but they exaggerated it and made it seem worse. Or it can go all the way down to complete lies with the intent to get a person in trouble. I want to get that person in trouble. I have my own reason. I want something else, so I'm going to fabricate something so I can get what I want. There's different levels. But this is why our confrontation system and the justice system is so important, is so we can get in there and find out what's going on. Now, they talked about the one witness rule, and like I said earlier, it's based off of the hypothetical and the premise that you believe the witness, okay? Does everybody agree with that? That if you believe the witness and they prove all the elements that are required for you to find a person guilty, you can still find that person guilty, even if it's one witness, because you believe that witness. What is your number, ma'am? 70.
This is just based off of testimony only without any other,
Correct. So juror number 70, that is correct. But again, it's based off of the premise that you believe them.
this through the cross-examination.
It'll include after cross-examination, it includes all of it. You believe them. And you'll still be able to follow the rule. Will everybody be able to follow that and tell the judge, I can follow the law? Just like I came down here today, because I didn't want to come down here today. I had other plans. I had work. I had children to watch. But I followed the rule. I followed the law, and I came down here. You're also telling me that you guys can follow the law and still find a person guilty if you believe that one witness, right? Okay. But like juror number 70, I think was starting to get to, your job is to judge that witness. What was the other evidence? Did it match the testimony of the other witness? Did it match the pictures? Did it match what the officer saw when the officer got to the scene? Is the witness lying to you? That is your job to be able to judge that person. Now, after you've done all of that, then and only then does the rule apply. But does everybody also agree with me that you understand your role as a juror, if you're selected, is to judge the credibility of the witnesses and the evidence presented? Does everybody agree with that? Juror number 68. Stand up.
I
Yes.
said something earlier, but I like the from a religious standpoint.
Okay. Okay, I think the judge narrowed it down to a different part of it, but I will make sure that Ms. Franklin notes that so that we know that we're going forward, okay? Anybody else agree, like juror number 68, that you cannot stand in judgment of another person? Anybody? What's your number? Juror number 18. Go ahead and raise your hand. Juror number 42 and 61. Anybody else? Okay, thank you for letting us know and bringing that up. Now, we also talked about it, the right to remain silent. It's been said in many different ways, but there's a difference between you want to hear from somebody and you need to hear from somebody. And we all also discussed, and I think we all understand, my client has that constitutional right to remain silent, meaning he doesn't have to present any evidence, he doesn't have to take the stand. However, knowing that that is the law, is there anybody that's going to require him to take the stand? Anybody? No? Awesome. And nobody's going to hold it against them for requesting a jury trial, right? Nobody? Okay. Okay, the state covered the law wonderfully. Let me go back. Does anybody remember the 5 W's and 1 H? Nobody? Go. No, wait, who's saying it? Juror number 74. What are they? Stand up.
Who, what, when, how, why, and how.
Who, what, when, where, why, and how. That's kind of a simplified way to be able to explain the elements of the crime. Who, what, when, where, why, and how. Except for the state usually does not have to explain why, but there's an exception because there's always an exception to the rule. We're going to try to get through this as quickly. They already covered mental states. Self-defense. When the issue of self-defense gets raised, that's going to go to your why. Your why did the person act the way that they did? Why did Mark act the way he did? There's your why. When self-defense is raised, the burden now shifts to the district attorney's office, the state, to be able to explain to the jury and prove to the jury beyond a reasonable doubt, my client was not justified in using self-defense. Does everybody understand that principle? Same for defense of a third person. We don't have deadly force here. The use of the force in order to protect themselves does have to be reasonable, and there will be a legal definition that'll be given to the jury with that. The jury does not have to agree why my client needed self-defense. They just have to agree that the state of Texas did not prove beyond a reasonable doubt that my client is not justified.
5 minutes.
Consent. That is another one. Consent means when the two people have consented to engage in a physical altercation. Now, the easy way to look at it is the boxing match. We have two people ready to square off. They're clearly in their boxing shorts and they have their gloves on. And we know that they both want to engage in that physical altercation. Sometimes it's a little bit different. See roommates fighting, siblings fighting, again, roommates. But there's ways to be able to tell if there is a consent between the two individuals. You can look at verbal evidence, the things that were said before anything happened. You can look at nonverbal, and you can also look at what, the actual technical stuff of what they said, the fighting words. I'm going to meet you outside. We're going to take care of this later. There's a lot of different things that'll play into it. But again, it's just like the self-defense. Once that consent issue gets raised, the state of Texas now has the burden to prove to the jury it was not consensual, okay? But there's a lot of things that the jury will look at to be able to get there. Now, who here believes that a man should never hit a woman? Anybody? Okay, we're going to go through this line by line. I'm sorry, can you flip here?
Oh, I'm sorry.
Jurors number 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, 18, 20, 21. You guys can put it down. 22, 24, 25, 27, 28, 29, 30, 32, 33, 36. In the back corner, what was yours? 37, 40, 41, 43, 47, 48, 52, 53, 54, 60, 59, 58, 57, 64, 68, 67, 66, and 74. Now, even though the law given to you will tell you there's no gender requirement with whether or not a man can use self-defense, is there anybody in the numbers that I just read out that is willing to change their mind? So I don't know if I can ask, let me see if I can fix that a little bit. The law says there is no gender requirement. A man can use physical force if it's under self-defense or under consent, even if it's against a woman, okay? There's no requirement, like a man does still have this right to be able to do it. Now, knowing that's what the law is, with the people, the numbers that I just read, do you still believe that? Are you telling the judge you will not be able to follow that law? Or is there anybody that wants to change their answer?
Question, just to make sure I'm understanding it right. So a man cannot hit a woman, but if the man is trying to defend himself from that woman, that's okay?
Yeah, so what I'm saying is, I just explained consent to you, consensual fights.
Yes,
We just explained self-defense. A man, the law says, and the law allows for a man to be able to use those two things. Knowing that's what the law is there anybody here saying, I still believe, no matter what the law says, I still believe a man can never hit or put hands on a woman? So what I'm saying is there anybody that wants to change their answer from what it was before? Okay. So,
Pause for one moment.
yes, ma'am.
Here's the question, everyone.
Sorry.
No,
Sorry about it.
yeah, here's the question. Self-defense can be used as a defense by a man or a woman. So self-defense says that in certain legal situations, that if someone is attacked, they may use self-defense. Does everyone understand? Is there anyone here who believes a woman cannot use self-defense? Anyone here who believes that? Raise your hand. Is there anyone here who believes a man cannot use self-defense? Anyone? All right, now let's do this. Is there anyone here who believes that a woman can't use self-defense against a man? All right. Is there anyone here who believes a man can't use self-defense against a woman? And realize we're speaking hypothetically. The situation may be, maybe a female is trying to shoot a man. Is that male allowed to use self-defense? It could be any type of hypothetical. All right. So is there anyone here who believes that a man should not be allowed to use self-defense against a woman for whatever reason? Raise your card if you believe a man should never be allowed to use self-defense against a woman. All right, number 15.
15.
All right, you may continue.
And along with that, it's also with consent. So everything that the judge said, it also applies to a defense of consent, okay?
You have 5 seconds.
Just trying to flip to this last picture.
That's time.
Here's a different view, something to keep in mind. There is always another, there may always be another way to look at things. And that's just what I want you to keep in mind. Is the state of Texas is gonna wanna make you look through a hole and see that raining backyard, okay? But what we hope is when you look at all of the evidence presented to you, and then after standing up over that fence and looking at everything, will you be able to make the decision on whether or not a crime occurred? Thank you for listening, and I hope I got past juror number 50.
All right.
Thank you.
So ladies and gentlemen, this is what is going to happen. I'm going to give everybody their lunch break so the court reporter can take a break because as I told you before, the court reporter has been writing down everything that everyone has been saying. So there are plenty of places to eat here. The cafeteria downstairs is open. There's also places along the Riverwalk. And if you just walk around, I believe on Houston Street, there are more places as well. We're going to come back here at 1:45. That should give everybody a chance to walk and find a place and not rush eating. As my mom said, don't rush your eating. At least chew at least 3 times before you swallow. All right. So you don't know anything about this case. You're not allowed to do any investigation. Does everyone understand? Make sure those juror badges are on because sometimes attorneys are walking around talking about different cases and they may or may not be talking about this case, but everything that you're going to need to know about this case is to come from inside the courtroom. Does everyone understand? All right, so I'm going to ask everyone, please leave the numbers and take your personal items with you. And everyone, make sure you're lined up in the hallway at 1:45. All right, everyone, please rise.
Leave it. Well, I was gonna say, if